baby more than I want to help her, but I know they won't take her in any of our programs because of that. She's been extended on probation, so
Yes, ma'am.
she's towards the end, and it's my understanding from Miss Holmes, who's worked very hard on it, that she just wants to sit out her time. But you understand my concern with the situation that she's in. It may not be the right thing to do, just to let her go sit there for a little bit of time, and then we have no idea what she's doing, and she's pregnant.
And in regards to, I know there was a recent drug patch result. So Ms. August, to my understanding, has denied any substance. The drug patch keeps registering saying cocaine, which was, as I think the results were from last week. And so that's why we asked if she could drug test today, because she has denied being, using those substances. But we do understand the concern, but we wanted to, I guess, shed some light or give, I guess, everyone, let them to breathe a little easier with her taking a test today showing she didn't have anything in her system.
And she tested in court also, it looks like March 2nd, and tested negative.
Right.
And then there was a drug patch that tested negative back in. So there's been kind of both. How far along are you? That was.
You know how far along your pregnancy?
I just found out literally like four days ago. My first travel stuff. So.
I mean, it's the type of case and the type of issues on a case that a 1244 has been fairly normal. I understand and have the same concerns, but I don't know that forcing anything is the thing to do, or if it's the fair thing to do either.
I just wanted these issues to be.
I'm with you
aware.
on what I'm concerned about, Miss August. I mean, we're both concerned, and I know everyone here, your probation officer, even your attorney, we're concerned about your baby. My concern for you kind of goes away once I know that you are with child and have had some issues with drugs. We want your baby to be safe, but you've also been on probation for a state jail felony for longer than you would have been doing state jail time with some hiccups. So it makes sense what they're talking about. But if you're having issues, you need to do whatever you need to do to be safe and have your baby be safe. Okay.
I'll send that paperwork.
Thank you. All right. I'll take care of it. Y'all have a seat and I'll take care of it as soon as it comes through.
Okay.
And is the intention for Ms. August to go today and be
Yes,
sentenced? Okay. Yeah. And all right, ma'am, again, you are Jamaica August.
Yes.
And Ms. Holmes, will your client waive the formal reading of the motion?
Yes, Your Honor.
Ms. August, in cause number 21-36752, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation November 28th of 2022 for the state jail felony offense of unauthorized use of a vehicle. And that was a 2-year deferred probation, and that's been extended. Is that correct?
Yes.
It alleges you violated your probation. Count 1 alleges that you committed the new offense of resisting arrest, search, or transport on August 10th of 2025. Is that true or not true?
That's true.
Count 2 alleges that you committed the offense of criminal trespass on August 10th of 2025. And is that true or not true? Count 3 alleges that you failed to remain off the premises of any bar, tavern, or lounge, and that you were at Little Woodrow's August 10th of 2025. Is that true or not true?
Sure.
Count 4 alleges that you were at a location other than your residence at approximately 1:37 a.m. on August 10th of 2025. Is that true or not true? Count 5 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you provided a urine sample July 29th of 2025 that tested positive for marijuana. Is that true or not true? And then count 6 alleges that you're behind in your court assessed fees. Is that true or not true? Did you enter your pleas of true to counts 1 through 6 freely and voluntarily? And did you plead true to those counts because they're all actually true? I have here on the tablet some documents that Oh, it's county jail, not state jail.
Yeah,
Correct.
Plus 44, yes.
Okay. There's a spot for county jail.
Oh, yes.
With y'all's permission, I'll
Yes,
make
ma'am.
that change. Okay, I have some documents here on the tablet that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenors number 1.
No objection.
It's admitted. Is there any evidence that Ms. August is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. And at this time, I find you guilty of the state jail felony offense of unauthorized use of a vehicle. Sentence you in accordance with your agreement to a term of 8 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. Good luck to you, ma'am. I really do. We all hope that you make the changes that you need to, so you can raise your babies and nobody else. All right, you can go back to the bailiff. All right, again, sir, you're Correll Gilbert.
Yes, ma'am.
And Mr. Gilbert tested negative for everything. And so Mr. Gilbert was previously in court in cause number 25, DCCR 1009, entered a plea of guilty to the 3rd-degree felony offense of driving while intoxicated, 3rd or more. I've received that pre-sentence report. Has everyone had an opportunity to review that report?
We have, Judge.
Yes, sir.
Any additions or corrections?
No additions or corrections, Your Honor. However, we did have one recommendation adding recall.
Sure.
Nothing finished up.
So with regard to, obviously, the recommendation here is for safety. What is your request on that, Mr. Chavarria?
You may make argument with that or
Yeah,
just.
go ahead.
Okay. Our specific request is that be held in abeyance and that Mr. Gilbert be asked to submit to some recurring UAs so the court is satisfied with his compliance and his progress on this offense. I will note a few things, Your Honor. Mr. Gilbert took responsibility for this as part of the pre-sentence investigation. He took responsibility for it at the scene, actually, as well. He has been working, had a good job with good pay for about 3.5 years, Your Honor, as a welder. And he's married. He has mortgage and car and all the normal things that people are expected to have. I think he's in a good position in his life, and submitting him to this safe P would be a major disruption to that. As for the actual plea agreement that was agreed upon, safety was not requested by the state. That was not part of the specific terms at that time. He was also seen by a individual named Miss Melissa Posey, who's a licensed chemical dependency counselor, and that's on page 3.
Mhm.
And her recommendation was that he enroll in and successfully complete an intensive outpatient program, such as the JCDI. And we would be in agreement with that as well, Your Honor, if that's appropriate, in lieu of the safety.
What's your position, Mr. Smith? Are you?
Judge, it wasn't part of the plea agreement. I didn't think that it was necessary at the time that the plea offer was made. The only thing that concerns me is the fact that he tested positive for alcohol when he did the concern, but we would leave it up to the court.
Was there an alcohol test done today on Mr. Farrell? It doesn't show that. Do you have the alcohol tests that you can do today?
Yes, ma'am.
I meant for that to be done as well. Can y'all get that done real quick? Let's test for that.
Thank you.
Sure, sorry, I'll hold it again just for a minute. Have I?
11 and a half years citizenship.
Okay, so you're Thomas Valentine. Have y'all have an opportunity to visit Mr. Rojas about the paperwork and I guess the
Yes, ma'am, it was a miscommunication, but both of us, I actually wrote 16 months. He remembered signing 16 months, but we obviously made a mistake. Paperwork says 18. If the court remember, he has credit for enough credit to cover the 18 months either way.
Okay,
And so we just want to make sure that that we were both okay with the 18 months.
okay. Any other issues? All right, then, Mr. Valentino, I'm going to find that you previously entered your plea of guilty freely and voluntarily. At this time, find sufficient evidence to find you guilty, and in clause number 25, DCCR 0121, find you guilty of the state jail felony offense of theft of material. Sentence you in accordance with that agreement to a term of 18 months in the state jail prison. You do receive credit for any time that you were in custody, that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back to the bailiff.
And Judge, if I could just for Mr. Valentino's benefit, the last time we were here, we checked his credit. He has 655 days credit. It wasn't attached to this case because he didn't have a hold on him, but the court had agreed to give him credit for that last time we were here.
What was it on? What was he sitting on? I remember talking about that.
Straight from us. And never left custody.
Yes.
Right.
Yes, so.
So I gave him credit from the day that he was arrested on our case because you never got out. Correct. Okay, you'll get all that credit. We'll take care of
May I
it.
ask you also, Your Honor, would you be able to, would the court be able to
See, he's asking if there's anything the court can do to make sure, he knows he's gonna have to sit for some period of time until the state jail gives him the okay to be released. He's wondering if there's anything the court can do to speed up that process.
My clerk is very efficient, so we'll have your judgment done within a day or two max. And so the jail will have it this afternoon or tomorrow. And then it's up to state jail to get back to them and get you, I guess, your number and hopefully get you out from there. But that'll be all up to them.
you got all the credit, right?
You have all the credit. Yes, sir.
It was 655.
Yes, sir. From the date of the arrest, because you never got out, we're giving you credit for all of that.
Thank you.
Yes, sir. Take care. So I'm going to order that do you already have the auto ignition interlock device on your vehicle? So you're going to continue with the auto ignition interlock device on your vehicle. I am going to order at least until you successfully complete JCDI that you also wear a scram device. And that is a device that's on your body. It's like a bracelet thing on your ankle, I think, and it touches your skin and it will test positive or show if there is any alcohol in your system. Because it's not just that you don't drink when you drive. On this probation, you're done with alcohol, period. And that will show me if you're drinking at all. If you successfully complete JCDI, I know that's a financial burden. If everything goes well, you'll be able to request probation, take that off. And at that point, if everything's going fine, you can take that off and then just keep the auto ignition interlock device. But until they tell you you can take off the scram, you keep it on and obviously test negative. And do everything you're supposed to. And so if you do all of that, this is a great opportunity because for all practical purposes, your case here in court is over. You'll serve that 10-year sentence while you're out on probation. The other side to that, however, is if you violate any condition of probation, you're back in court and you're facing the 10-year sentence that you've already agreed to. Do you understand?
Yes, ma'am.
And so what are you're working now?
Yes, ma'am.
Same job for the last 3 years or so. So what are your hours? Are y'all requesting weekends or do you have some time off where you want to go do your 10 days?
Weekend because you're.
So any issue with me ordering weekends? So Mr. Gilbert, I will allow you to serve those, the 10 days on weekends. You will start those weekends this weekend. You will turn yourself in Friday by 6 o'clock p.m. It's important that you're on time. If you're late, that could be a violation of your probation. Obviously, if you show up under the influence of anything, it's a violation of your probation. And then you'll serve weekends. They'll let you out on Sunday evenings and you'll serve however many it is until you satisfy that 10 days. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can speak with your attorneys. So you just need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork. All right. Good luck to you, sir.
Thank you.
Thank you, Mr. Shawaria. Ms. Holmes, you got Jamaica August. I've got that. All right, sir. Again, you're Brandell Griffin.
Yes, ma'am.
And it's my understanding that you guys have come up with an agreement instead of going to trial. Is that correct?
Yes, Judge.
And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
Looks like we're going on a lesser, correct?
Yes, Your Honor. Attempted, which makes it Class A misdemeanor.
All right, let me get that pulled up. Okay. Okay. So Mr. Griffin, in cause number 24, DCCR 1666, the state has elected to proceed on the lesser offense of a Class A misdemeanor, attempted publishing or threatened to publish intimate visual material from June 24th of 2024. How do you plead it?
Guilty.
Are you pleading guilty freely and voluntarily? And because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
No.
And you understand if I follow the agreement that you made with the district attorney, you'll be waiving or giving up any right to appeal. And it looks like the agreement is for 30 days in the Jefferson County Jail that y'all have checked, and you have credit for 14 already.
Correct.
And the agreement is for me to reset sentencing to a different date so that you have time to kind of get your affairs in order so that you can go serve that time out. Is that your understanding?
Yes.
And are you a U.S. citizen?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Griffin is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing to the 22nd. The 22nd, it's a Wednesday, so it's kind of a different day because of that week is kind of an off week. So we'll have docket at 9 o'clock that morning. It's very important that you're here, obviously on time, and also that you are not arrested for anything between now and when we come back, and we'll go forward with your sentencing at that time. And we do not need a pre-sentence report. All right, we'll see you back at sentencing.
Thank you.
Thank you. Thank y'all for working that out.
Yes.
All right, sir, you're Terrell Coker.
Yes.
And will your client waive the formal reading of the indictment?
He does, Your Honor.
Mr. Coker, in cause number 25, DCCR 1221, you're charged with the state jail felony offense of solicitation of prostitution from March 28th of 2024. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Samuel? Do you fully understand them? And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Coker is not competent?
There's none.
And Ms. French, is there any history that you know of, any reason not to waive pre-sentence report to
No,
the
Your
state jail? Are you in agreement with waiving the pre-sentence report? Then at this time, Mr. Coker, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea. I'm going to waive the pre-sentence report, find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $300 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation, if you successfully complete it, the case will actually be dismissed. You'll never have a felony conviction. The other side of that is if you violate any condition of probation, you can be brought back into court. Found we were in court that day that there had been 15, I think it was, positive drug results, patch results that we had not received. We received on that day. I raised his bond on that day, went into custody, has made that bond, has a drug patch on, and the first drug patch received tested positive.
That was the one I had. That was the one that I had.
So you still had the one in court when they didn't take, you didn't take it off in jail. How long were you in jail?
Like overnight. I got out when I got out the next morning. They told me to go change it.
Did you?
Yes, ma'am.
So when are you supposed to switch this one?
I just did a switch Monday.
Oh, you already did the switch Monday. So we should have a result within what, a few days, Anna? Do you know how long that takes? Okay, well, that at least somewhat explains that if that's correct. So I want to make sure you understand, obviously, I'm going to get that result within a few days. If it's positive, your bond's going to be high enough to where you're not going to just make it out overnight. Do you understand? If you test positive again for anything, you will be back in custody. We'll have a hearing. And at that point, based on the length of time, there are sometimes I can make findings that bonds are not even appropriate. So you better not test positive. You better not be around anybody that's doing it. You better not come in and say, I didn't do it. I touched something or somebody touched me. No excuses. This next one better be negative. Okay. All right. Y'all are free to go.
Thank you, Your Honor.
I'm sorry, Judge.
Yes.
I didn't want to interrupt you. In light of his criminal history, would the court consider, now that he's back out on bond, a GPS launcher in this case?
What's the underlying offense of aiming? I mean, he showed up every time. And there's not necessarily a complaining
I
witness.
just wanted to ask. It's
Okay, yeah, I would say if there's any other issues
something comes
that
up, I'll
comes up, let me know and file something. Otherwise, my main thing, he's been here every time. We just didn't realize he was testing positive for that long.
I did.
All right, you're free to go.
Thank you.
Mr. Crane, so you are going to have a baby today, is that right?
Yes, ma'am.
Well, here's what I'm going to do. Your attorney's talked with me. The assistant district attorney is not arguing against me doing this, what he's requested, but I want to make sure you understand what all of this means. I'm going to let you turn yourself in this Friday at 12:00 noon. All right. So that gives you a couple of days to get everything taken care of, see the baby born, and then you have to turn yourself into the Jefferson County Jail by noon on Friday. That's part of your probation now. And so what that means is if you don't turn yourself in on time, it's a violation of your probation. And so you're going to be right where you don't want to be, right? So I know you don't want to go for those 3 months, but it is intended to help you make better decisions. 3 months is better now to miss out of your child's life than potentially 5 to 99 if you violate your probation. So go listen, get the tools you need, turn yourself in, make some positive changes so that you don't ever have to look at me in this position again and we're not here having some really bad conversations, okay?
Yes, ma'am.
So I'm going to let you go today. I'm going to let you turn yourself in on Friday, and then hopefully everything goes just like we already talked about and you change your life and we're in a good place, okay? All right.
Thank
You can go back and they'll let you go from back there. Thank you.
Thank you.
Good morning, sir. Are you William Bonilla? And Mr. Bonilla is charged in clause number 25 DC 719 with evading arrest or detention with the use of the vehicle. And what is the announcement?
Judge, this also is a motion to revoke based on,
Oh,
based on that. Yeah, he's got evading.
oh, I'm sorry. There's two cases. So
Yeah.
we've got a new case of evading in that case, and then we've got 25 VCCR 0174, a driving while intoxicated that he's on probation for.
That's correct, Your Honor. And I spoke with Mr. Conlon about this last week, and I got the video finally on Friday. If I can get one more reset, I'll have a chance to look at that and get Mr. Boney in to look at it and be able to make an announcement next time.
It's not opposed, Judge.
All right, Mr. Bonilla, I'm going to reset your case, a normal reset. Make sure you go in, visit with Mr. Rojas so y'all can go over everything, review everything he has, and we'll get an announcement at the next court date. Okay, you're free to go. Good morning. You are Brendel Griffin. And Mr. Griffin, in cause number 24 DCCR 1666, you're charged with the state jail felony offense of publishing or threatening to publish intimate visual material from June 24th of 2024. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
And I have a plea bargain rejection that you've signed with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And that would be for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $1,000 fine and follow all of the rules and conditions of probation. You have every right to reject that offer. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you want to reject that offer? All right, we'll get that case set on the trial docket. And Mr. Griffin, Mr. Rojas has been appointed to represent you at this point. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint someone else. Is that okay with you? So, Mr. Rojas, you are released. Mr. Griffin, we will appoint someone today. If you'll have a seat on this side of the courtroom, watch for the clerk. She'll
A probation hearing took an unexpected turn when Jeremica August revealed that she had recently discovered she was pregnant. The court was already dealing with serious probation violations, including new criminal charges, being in a prohibited location, and a failed drug test. However, August denied using drugs, and recent testing showed negative results. The judge carefully considered her pregnancy, her probation history, and the concerns raised by both her attorney and probation officials. After reviewing the violations, August pleaded true to all 6 counts. The judge revoked her probation and sentenced her to 8 months in the Jefferson County Jail under a special sentencing provision. But before ending the hearing, the judge delivered a powerful message. She reminded August that the goal was not only punishment, but also making the changes necessary to protect her future and her children. Now, the big question is: was the judge right to balance accountability with compassion in this case?